Welcome to the People Relations Podcast, the podcast series brought to you by People Relations HR Consulting, where we talk with business and HR leaders around the globe. In each episode, we will discuss exclusive insights, strategies, and advice to help you make better people decisions in your business. For show notes and incredible bonus resources, simply visit www.peoplerelations.com.au. Okay, let's get started. Hello, everyone, and thanks for listening. Good to have you along. Today, I'm looking forward to my conversation with Richard Gunningham. Richard is an experienced lawyer and partners with us, the human resource, and he specializes in employment, safety, and industrial relations law in Australia. Richard, thanks for joining me today.
Thank you very much, Pam. Pleasure to be here.
So today we're going to talk about how to make sure your independent contractors are not your employees. And we will share some practical advice on how to approach this common question, which can cause significant issues for your business if you get it wrong. So at the Human Resource, we regularly are asked about the difference between contractors and employees. And sometimes what happens is individuals seek a contracting relationship for tax benefits. They might tell an employer that they choose to be a contractor and they are okay waiving their employment rights in favor of this type of relationships. However, this choice is not theirs to make. And in Australia, the day-to-day nature of the employment relationship is mainly defining whether somebody is a contractor or not, or an employee. So really, people cannot choose to opt out of employment entitlements, and they cannot opt out of tax requirements. So there are a lot of implications in terms of the nature of the contractual relationship, and this is what we're going to be discussing today with Richard. Richard, can you tell us how to know the difference between independent contractors and employees, and why it is so important to make sure this is clearly defined nowadays?
Sure. Yeah. So you're spot on when you say that it's not up to the company or the individual to deem whether a relationship will be an employment relationship or an independent contractor relationship. That's a matter of law. In the eyes of the law, whether or not you're a contractor or an employee is going to come down to, a couple of recent High Court decisions that we'll talk about today. And it's very important to make sure that you correctly characterize your workers as employees if they are employees in the eyes of the law, because if not, then you can expose yourself, your company, to claims for back paid employment entitlements by the employees themselves. If you're engaging them as a contractor, but they're actually an employee, they may make a claim against you for employment entitlements or entitlements under modern awards. Which they might be entitled to because they're truly an employee. You can also run the risk of being audited by the ATO, Australian Tax Office, for example, in relation to whether or not you're properly paying superannuation. And you mentioned payroll tax as well. You could be audited by the state regulator to make sure you're properly paying payroll tax in respect of your employees. And if it turns out you're characterizing as employees as contractors when they're truly employees, then there's these risks that arise. So and it's very topical at the moment because of these two High Court decisions that we had earlier in the year.
Yes, getting it wrong can cause significant issues and costs in different fronts, right? Like tax, super, employment law, and company reputation as well. Plus, obviously, the headaches of having to deal with this matter. Can you tell us a little bit about the most recent court cases and what's coming out of?
Yeah. So up until earlier this year, the courts would look at the totality of a relationship to work out whether or not a person was a contractor or an employee. So the courts would look at things like do you control how this person performs their work in practice? Like, do you require them in practice to wear a uniform, to turn up to work at a certain time, to perform certain duties? And when there were disputes about this, the parties would put on evidence about what happens in practice. Earlier this year, the High Court said you no longer look at what happens in practice if you've got a comprehensive written contract that governs the relationship. And so if the written contract outlines that, a company doesn't exercise a lot of control over the employee or over the individual, and if it outlines that the individual is performing work in their own business as opposed to your business, then the contract will be deemed to be a true independent contractor relationship as opposed to an employee relationship. And the court said, you no longer look at what happens in practice, you just stick within the four walls of the contract. The only time that you go beyond the four walls of the contract, the written contract, is when there may not be a written contract at all, or the terms of the contract are, really unclear and ambiguous about the relationship between the parties and what one person expects of the other. So these High Court decisions are useful for companies because it makes it a little bit more certain about where you go when you're working out whether a person is a contractor or an employee. You just look at the terms of the contract as opposed to what happens in practice. So it's a benefit in that sense, but it also increases the risk because your written contracts have to be really well drafted. And if you're engaging independent contractors, you have to make sure that you don't, as I said, exercise too much control over the individual.
Exactly, Richard. So you are respecting the nature of the relationship that commences with a key instrument that is a clear, defined, and clearly drafted contract to avoid any issues. It's important a contract well written to begin on the right foot with the employment relationship, and also in the eyes of the law, as you were saying before, showing, okay, this is the agreement that we have.
Yeah, so it really comes down now to, well, what do the terms of the written contract say, as opposed to what happens in practice after the contract is signed. I think this might lead to situations where companies, may represent one thing in the written contract, but then do another thing in practice, which is obviously not necessarily a good thing. But the way the law sits at the moment with the two High Court decisions is that the courts and the Fair Work Commission can't go beyond the terms of the written contract to look at that post-contractual conduct, provided, as I said, that the written contract is comprehensive and unambiguous between the parties.
Absolutely. There has been a lot of debate until now. What do you think, Richard, is the government going to do to help employers and employees, independent contractors, to help to clarify, to make it easier for individuals?
Well, the Labor government has been pretty open so far that they're going to try and give the Fair Work Commission powers to make orders for minimum standards for these sort of employee-like forms of work, which would apply to gig economy workers, for example, or Uber drivers, Deliveroo drivers, the like. The government seems to be indicating, although they haven't released any specifics yet about how they're going to do this, but they're indicating that they want to give the Fair Work Commission powers to make orders around those sorts of arrangements and set minimum minimum standards. So the Labor government went into the election with promises around that, and they do seem to be following through on that. There was the Jobs and Skills Summit earlier this month, where the Labor government was public about the fact that it was going to try and give the Commission these powers to regulate what I guess has traditionally been viewed as perhaps a more independent contractor-like relationship with the gig economy. So it'll be really interesting to see what the government does to try and, in its eyes, protect those workers. I think it'll be a bit of a wait and see, but I expect in the next 6 months or so, we'll see what that legislation might look like.
Right. Yes, we'll have to keep an eye on that for sure. As with any legislation updates or changes which occur on annual basis, if not, same as what has happened with the relationship between employers and casual contracts as well, defining
true.
that. And obviously, HR professionals and lawyers, in this case, you, Richard, as well, keep on top of all those changes in court cases in order to be able to provide the right advice to employers to set up the right contracts or the learnings that come out from court cases, and what are the changes in legislation and what is it that comes out from learnings from these court cases, as we were saying, for sure. Richard, before we were talking about obviously having the right contract in place, keeping an eye on what's coming up. What do you think are the main clauses that should be included in the contractor agreement?
Yeah, well, they're clauses that if you're setting up an independent contractor relationship and you want to make sure that there's not a risk that your independent contractor will be deemed an employee, the sorts of clauses that you want in the independent contract or the independent contractor agreement are clauses that give that worker, the independent contractor, control over how and when they perform the work, as you were saying before, Pam. That they are required to provide their own tools, required to provide their own vehicle, that they're responsible for their own insurances, for example, that they can delegate the work as they see fit. So all these sorts of things give control to the independent contractor about how they perform their work, as opposed to the company exercising that control over the independent contractor, which is more of an indication of an employment relationship.
Absolutely.
So clauses like, the contractor can provide, can engage and provide other personnel to perform the services. Contractor will provide all their necessary tools, vehicles, and equipment at their expense. The contractor may offer services to other clients. They're responsible for insurances. All these things will are important in a true independent contractor agreement. There was some guidance that we've had in the last 6 months following the High Court decisions from some cases that are applying those High Court decisions. So there was a decision in a federal court a couple of months ago in July, the case of the Fair Work Ombudsman and Avert Logistics, AVERT Logistics. And this was one of the first cases where the court, went line by line through a contract to make a finding about whether or not these workers were employees or independent contractors, using the High Court decisions as a guide. And the main and ultimately they were found to be independent contractors by the court. And the main thing that persuaded the court was the fact that these contractors were incorporated or free to incorporate. So that seems to be still one of the defining factors of an independent contractor relationship where the worker is actually an incorporated entity, or there's an incorporated entity between the principal contractor and the worker. So there may just be one worker, but they're their own, they have their own company that employs or engages them. So there's that company between the two parties. And that's also very important for working out whether or not you've got to pay superannuation.
Yes, I was going to ask you, obviously, to bring awareness to our listeners, what happens with the superannuation payments for contractors?
Yeah. So this is an issue that one of the issues I see most often with our clients, that they're not aware that in certain circumstances they have to pay super for their independent contractors. Now, the easiest way to make sure you don't pay super to contractors is to make sure that your contractors are incorporated or they're a partnership or a trust. Because if you've got that body that you're contracting with, you don't have to pay super to them. But if they're an ABN holder, so they're not incorporated, they're an ABN holder, they're not incorporated, they're engaged principally for their labor as opposed to, performing a task, for example, then you do have to make super contributions for them. So if you've got, a tradie who you're engaging as a contractor, they're an ABN holder, they come to site and they perform work for you, then, you have to pay superannuation to their fund. And you can't do what some companies seem to think they can do, which is just pay a higher rate and say, well, this covers you for super as well.
Yes, which we see probably more often than not, right?
Yeah, I see it quite a bit. The obligation is to pay super directly to the fund.
Right.
So the easiest way to make sure you don't have to pay super to that sort of a worker is to require them to incorporate before you engage them, or require them to, become a partnership or a trust, and then you don't have to pay super on their behalf.
So as a practical example, basically for any industries, you offer independent contractor a daily rate that includes super, then you'll have to still pay super the same as the rest of the employees. Although it's important to highlight that the rest of the terms apply, such as what we were covering before.
Yeah, so there's what we were talking about before about whether or not a worker is deemed an employee or a independent contractor it is a separate issue to the superannuation issue. You can have a true independent contractor, but still have to pay super to them as if they were an employee, because the superannuation legislation can deem them to be an employee, even if under the eyes of the law they're an independent contractor. And as you said, the key criteria, just recapping them, are if you're engaging an ABN holder to principally for their labour, then it doesn't matter what the terms and conditions of your contract says, the legislation deems them to be an employee for superannuation purposes. It's a different situation if you're engaging someone to perform a task. So if you're, say, using the example of the tradesman again, if you say, well, I'm going to pay you, the tradesman, $5,000 to build a fence, then superannuation is not going to be payable because you're paying them to perform a task as opposed to principally for their labour. So that's a different situation. But if you're paying them a daily rate, as you said before, just to come and perform labour on a job site, or perform any labour on a job site, then superannuation is going to be payable if they're only an ABN holder.
Right. So there are a few things to assess before making a decision whether to include super or not. There is an assessment to conduct to do the right thing, because also you could have the right contract in place, but if the daily rate is incorrectly stated as, including or excluding super or GST, those are also terms that you need to look at to ensure that then there are no back pay claims or any disputes that make it hard for employers. So, Richard, to close, what are the key takeaways today for our listeners when it comes to making the difference between deciding whether go for an employment agreement or an independent contractor agreement, things to look at?
Yeah, well, I think the starting point is, work out whether you do want to exercise a degree of control over this worker and be able to direct them about how and when they perform their work. And if so, then they're better engaged as an employee. Of course, you'll have to pay employment entitlements to them, and they'll be subject to, they may be covered by a modern award and all the rest of it. But if you're content for your worker to, they've got the skills and experience to do what you need without you needing to exercise a lot of control over them, then, it's perfectly appropriate to engage them as an independent contractor. Once you've made that decision to engage them as an independent contractor, make sure that the terms of your written contract with them align with the characterization of the relationship as an independent contractor. So again, making sure that you don't exercise a lot of control over them in the terms of the contract, and making sure that they are performing work in their own business as opposed to in your business in the terms of the contract. And some of those clauses we ran through can help. And then finally, looking carefully at whether or not you have to pay superannuation in respect of your independent contractors. And my, default kind of suggestion for businesses is to engage with independent contractors who are incorporated, and that takes the guesswork out of whether or not you have to pay superannuation to them.
So yes, making sure the worker is operating their own business independently of your business. Well, thank you so much, Richard, for sharing your knowledge and expertise. With Richard, we support our clients by drafting independent contractor agreements and advice in relation to the agreements or how to fix them. So if you like to get in touch with us in our website for a free consultation, you can chat about your current contracts or questions, and we'll give you a hand. Thank you so much, Richard, for your time today. It's been very interesting and a pleasure to have you with us.
Thank you very much, Pam. Thanks for having me.
No problem. Have a good day. Bye.
You too. Bye.
Thank you for tuning in to the People Relations Podcast. We hope that today's discussion helps you find new ways to make better people decisions within your business. For additional insights and resources, remember to visit our website at peoplerelations.com.au. If you found value in this episode, please like and share the show with your friends who are dedicated to running and growing their businesses. We can't wait to have you back next time for more great conversations. Until then, take care and see you soon.